Hello, everyone. Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today, we have Mr. Kong with us. And Mr. Kong is a lawyer with 9 years of experience, having versatility in both civil and criminal matters, including matters involving construction law, company law, family law, and so on and so forth. So, Mr. Kong is also the founding partner of his law firm called Tan and Khong Chambers, which offers a broad range of legal services, catered from individuals, small enterprises to other bigger and established companies. Let's talk to him straight and get some more. Hello, Mr. Kong. Thank you for joining us.
Hello,
So, how is it going, Mr. Kong?
very good. It's
All
a
right.
pleasure to be here.
Yeah, same. We are actually equally delighted. So, Mr. Kong, firstly, I would like to ask you if it would be really nice if you can tell us something about yourself.
Well, I have stayed in many places actually, although I am a Malaysian citizen, but I was actually born overseas. So I have stayed in New Zealand and also the UK. So I did my primary and secondary education in Malaysia, but then I did go back to New Zealand once again to complete my undergrad. But the legal practice in New Zealand and Malaysia is slightly different, and I feel more at home when I deal with local issues at hand. That's why I came back. So yeah, I've been practicing for about 7 years by now.
All right, great, great. That was really nice. So now, Mr. Kong, you mentioned that there is a difference between practicing in between the two countries. So can you be more? Can you please enlighten us on how we can see a difference here?
Well, it's just my perception, but I think that the people in New Zealand are more peaceful, and they tend to settle things out of court quite quickly. So the lawyers there are also equipped with a slightly different skill set. For example, it's quite common for universities in New Zealand to teach law students soft skills like negotiation and mediation, and it becomes part of the syllabus. I think it's a little bit more different for even for those who graduated from the UK, where it's more book reading and it's more focused on the theory and practice in law. So New Zealanders tend to focus a lot on alternative dispute resolutions. And in Malaysia, we are always about going to court and fighting it out all the way. So we can see that one is more adversarial and one more is more towards collaborative negotiations when it comes to resolving a certain dispute. So that's one of the fine lines or distinction between practice in Malaysia and New Zealand, I believe.
All right, great, great, great. So, Mr. Kong, there's a common thing in between us. So it's New Zealand. So I graduated from India, but my graduation was a dual degree program and it was affiliated to St. Helens University, New Zealand.
Oh,
So
wow.
we have something in common.
That's very good to hear.
Yes, yes, yes. So, Mr. Hong, that was really nice. So now the pandemic saw some courts begin moving towards more remote proceedings and availability. Is this sustainable and a possible way to increase access to justice, in your opinion?
Well, for this question and also for other questions that you may ask, I just have to say first that I will be speaking from the perspective of a practitioner from Peninsular Malaysia. So even in Malaysia, we actually have three different separate bars. The one in Peninsula and the one from the Borneo Islands, which is Sabah and Sarawak. So now on remote proceedings, yes, the advent of remote proceedings took the Malaysian civil litigation sector like a storm, and certainly lawyers who weren't into technology were actually forced to adapt one way or another. Most criminal matters, however, are still proceeded physically, since there is an expectation of open accountability where justice has to be done and seen to be done. Now, on sustainability, as technology improves into the future, it will become increasingly expedient for court proceedings to be conducted remotely. The problems with the present way, however, that remote hearings are conducted is largely due to technological limitations. So firstly, on issues of latency, which has a lot to do with the quality of broadband services, as well as the capacity of devices used. So although most internet users now possess 5G, all it takes to disrupt court proceedings is for one participant to have a really bad connection. And the second concern is the limitations to reading a participant's body language and to interpret non-verbal cues with a sufficient degree of precision. Since it is excruciatingly difficult to achieve eye contact through the lenses of a webcam. Other parts of the body also cannot be seen on screen. So as hand gestures and certain positioning of the body would be off screen. So these are observations which we trial lawyers often employ in the midst of a witness examination. So when we are deprived of these things, the quality of, especially in cross-examination, diminishes. But although I guess for now, we will still get through with just the oral answers and the occasional facial flinch from the witness. But I do hope that with the increasing use of technology, maybe technology would in fact advance faster when we will all soon have zero latency connection, and maybe participants in the conference would in the near future even appear in, who knows, maybe 3D or maybe even a holographic form like in Star Wars. So that would all be attributive towards the sustainability of remote hearings. As to access to justice, I have no doubt that remote hearings would definitely increase access to justice, where less travel and a higher reliance on remote hearings would mean lesser cost payable by a client and more time for lawyers as well. In fact, I even have a client right now whom I have actually never met before and who resides overseas. And I'm only able to represent his interests effectively because of this new start of this remote technology. And he's actually hopeful that the trial will be done remotely as well, so that he doesn't have to travel all the way down to Malaysia as a witness when it does come the time. So that's my take on the issue of sustainability for remote hearings and its accessibility to access to justice.
All right, great. So that's the beauty of technology. It connects people, yeah, from one end to other. So that's the beauty.
This isn't it?
Yes. So in my opinion, what I have gathered till now is that you are really into technology because
yes.
Yes. So yeah, because it helps to cut the commute time and everything. So it's really nice. So Mr. Khong, now I'd like to ask you, how do you rate the current legal system drive towards increasing access to justice? Is there tangible movement in closing the justice gap?
Well, I think that the Malaysian government has implemented various initiatives which has definitely made access to justice more accessible than it was in the past, maybe say 20 to 30 years back. The fear to the layperson has always been that if there's a legal problem, where to go, and when we either can't afford the legal fees of a lawyer or the value of the subject matter in dispute isn't quite proportionate to even the minimal fees payable. So in Malaysia, there are a few avenues in a situation like that. So we have the small claims procedure, and that's for disputes which does not exceed 5,000 ringgit. So that's not actually quite a lot, but so it's heard in the magistrate's court, and the individual litigants can't actually be represented there. The filing fees and costs are also quite nominal. So since laypersons are supposed to represent themselves, the courts there are also not so strict on the issues of procedural compliances. And then we also have other smaller tribunals, just like consumer claims tribunals for claims which do not exceed 50,000. And there's also this strata management and housing tribunals, which deals with matters of real estate. So again, similar to the small claims, these tribunals do not usually allow legal representation and is catered to helping the layperson resolve their disputes in an inexpensive way. So there are also other forms of tribunals outside this framework from the ordinary civil court structure. Now, the arising problem with these regimes is that these decisions are often still susceptible some way or another to an appeal or review to the High Court. And when that triggers, legal representation still comes in, and that's where the cost to litigate can still be costly. Although the initial hearing where the matter is resolved can be said to be cost-effective and affordable access to justice. If there is actually an area which is sorely lacking in accessibility to justice, from my view, that would be more of the criminal justice system in Malaysia. I actually used to do what they call a doc brief many years back, and it was one of the available legal aid programs which pupils could choose to join. So through doc brief, we actually loiter around the various criminal magistrate courts, and we will represent random accused persons to possibly do a mitigation or a guilty plea of some sort, or to even help them apply for bail. And from my observation, then what is perhaps rather disconcerting is that most accused are brought in unrepresented with little to no avenues of legal representation, and most plead guilty because of that. The high rate of guilty plea is also likely due to the inability to afford legal representation, in addition to suspected persuasion from arresting authorities to actually plead guilty. So although there are some initiatives, just such as that doc brief program and also the various legal aid programs provided, it is my view that these initiatives do not provide an adequate coverage. And so pleading guilty to some degree is often a choice of convenience rather than of guilt because of the lack of realistic resources to mount a competent defense through a trial. So I would say that there is much more that could be addressed on the accessibility of justice to Malaysia, especially from the criminal justice system. But to address matters in a nutshell, I feel that much has already been done to bridge the gap and to make justice more accessible for all. And it can be improved by accounting for the socio-economic conditions of the general population.
All right, Mr. Kong, that was really nice. I mean, this actually says it all. I mean, the understanding that you have of the legal space, it's really nice.
Yes, I think it has a lot to do with the affordability by and large. If people can't afford, then what other avenues can be created for them so that the law becomes a thing which is accessible to all.
Exactly. Exactly. So, Mr. Kong, as you know, that time is money in any profession, and in legal, it's most of all. So, how do you ensure to make the best of your time as a lawyer?
Well, honestly, I wouldn't actually be able to confidently boast that I actually made the most of the time that I actually could. And I think that if I really did, I would be a lot more successful than what I have achieved today. I actually see my other partner, Daryl, he's always hard at work. And he's often out and about meeting clients and trying to draw work into the firm. So he may have been the better candidate to answer this question. But for me, what I do is I actually spend the first few years of my practice, by and large, trying to master legal practice in every way I could. And that was my focal point at that time. And I recall back then that every new type of application or proceeding which I had yet to try, that always fascinated me. So I'll always be very excited when I was entrusted to examine witnesses during trial or to maybe even conduct a hearing. So I'm proud to say that I have actually been given and had the opportunity to gain quite a well-rounded exposure in various aspects of legal practice. But yet I still don't feel that I gained a complete mastery over it. So of course, I would definitely look at spending more time in that aspect. But I think that on hindsight, I would have, if I was to be able to reverse time, I would actually have focused a bit more on the social aspect of practice as well, such as building a clientele much earlier on. As the reality of practice is that there is nothing to practice at all, and no legal progress to demonstrate unless one actually has clients. So it would appear that mastering the law and building a clientele are actually complementary to one another. In any event, I guess that it's never too late, and I'm now spending a little bit more time improving in that aspect of practice as well. As to day-to-day routine, I always have a schedule of things which I want to accomplish every day. And I have all my work and incoming work organized in Google Calendars, which is shared with everyone else in my office. So that way, work can actually be properly distributed and is manageable. And it also accounts for everyone's schedule. So that way, time is maximized, not just for myself, but for all my other colleagues as well.
Mr. Kong, I suppose you are being really modest here because I also believe that if God permits me, I would like to travel, uh, I mean, to 10 years back and just start a new journey altogether. So that's how we learn things. So that's the process of life.
Yes.
Yeah. So that was really a nice answer. So you owe a law firm. So what were the main challenges for you that you actually faced in your journey in starting a law firm?
Starting out, Tan Khong Chambers was a new and fresh experience for me. Of course, since it was the first time that I not just started a firm, but also started a type of business in a way. So there were a lot of things which I had to learn, and not only to continue improving and becoming a better and more competent lawyer every day, but to also as a business owner and subsequently as an employer. I think the first challenge that I faced was realizing that I had no longer an employer above me. So I had to adapt from transitioning from being an employee to becoming an employer. Back then, as an employee, the motivation and practice was always to prepare good drafts, to do good work, and make sure, of course, that the boss was happy with my work. So it took a little bit more time for me to come to terms that uh, I no longer had a boss to impress, and slowly transition to become more service orientated since clients are the lifeline of the firm. That meant that doing a good job in court wasn't quite enough, as running and managing a case well, or maybe even winning a case, may not necessarily mean that clients would actually be happy if the client's objectives are not met, or if there wasn't enough interaction to ensure that the client felt that they were properly accommodated. So in fact, I once had a client who was not happy, although I was winning all the way. So one client, one day, the client said that uh, he previously engaged a very senior lawyer to act for him, and apparently it caused a bombshell. Yet, although he lost, even with senior counsel by his side, the client claimed that he felt as though he had won. So until now, I wonder what that really meant. I think that the most challenging aspect of practice in being a partner and also an employer is ultimately dealing with people, which is not an area which I was very attuned to at first. One thing I would definitely learn is that everyone has a different personality of sorts, and that not everyone would necessarily share the same worldview or perception that we have. So I, for one, I am usually very logical and analytical, but I noticed that many others do not necessarily share that same mentality, even for fellow lawyers alike. So some people, for instance, they tend to perceive things from an emotional spectrum rather than what may be logical and practical. So hence why perceptions even for simple matters can vastly differ. So I soon came to learn that the only way all these different personalities could possibly come together is if everyone were prepared to put aside their differences and explore common ground on which they all have. The ability to compromise without also compromising on well-being is thus a personal development that I would always seek to improve. Coincidentally, it is also one of the skills in dispute resolution that a competent lawyer must possess, since the reality of practice is more so about solving problems for people rather than just fighting out a case. So these will be some of the challenges which I did face in coming out on my own.
All right, I completely understand. So, thank you so much for sharing great insights with us, Mr. Kong. So
Yes.
we look forward to having a chat with you again in the future
That would
and
be awesome.
on some other trending topics in the international business industry. So for our viewers, if you like this chat with Mr. Kong, please like and share this video as much as you can, and also subscribe to Click Away Creators, the YouTube channel, to appreciate what we do. And you have more coming up from industry leaders. Thank you so much, Mr. Kong. It was a pleasure speaking with you.